to the webinar hosted by Lawyers Club India in association with Creators Legal and Trivikram Associates. We have a very special guest with us today, Senior Advocate, Mrs. Lakshmy Iyengar. Ma'am, it's absolutely a pleasure to have you with us today.
My pleasure.
On behalf of Lawyers Club India, Creators Mind and Trivikram Associates, I extend a warm welcome to you, ma'am.
Thank you.
Before we start today's session, I now request Mr. Govind Chaturvedi, Advocate, to briefly introduce our today's speaker.
Thank you, sir. Thank you so much. I'd just like to take a few moments to say, introduce ma'am. Lakshmy Iyengar ma'am is Lakshmy Iyengar ma'am, the senior advocate who's been practicing before the High Court of Karnataka and the Supreme Court. She has over 22 years experience in the legal field. She has represented very big bodies like Karnataka State Legislative Assembly Secretariat before the High Court of Karnataka and has appeared on behalf of the official liquidator before the Fugitive Economic Offences Court and the PMLA Court to protect the rights of the creditors in the UB matter. She was chosen as a senior advocate by the Karnataka State Law University to be part of their academic council. Her forte includes matters like where she appears in NCLT, NCLAT, the trial court and the commercial court, civil appeal matters, criminal matters, matters involving quashing FIR, writs against local bodies, copyright matters, service matters before the CAT, KSH, and such appeals, KSAT, and the such appeals before the High Court. Not only that, ma'am has been part of a lot of cases which have had a societal impact. One of those was the case when she assisted in ensuring that speed breakers are put before schools. In heavy traffic areas, the High Court directed the municipal corporation to put up these speed breakers. Thereafter, she also, another very important thing which she did, which is very important, is the fact that she ensured that the locking mechanism in taxi cabs is taken down and the removal of the system ensured that at late night, who were moving from one area to another, their safety was ensured. Not only that, other than being legal, as you would say, a senior advocate and very accomplished in the legal field, ma'am has also been a very avid sports player. She has represented the Karnataka State in basketball and cricket. Not only that, she was chosen as a South Zone wicket keeper at junior level. She has represented Bangalore University basketball and she also won the National Co-Fighting Championship. Now I hand over to sir. Thank you. Thank you.
Thank you so much, Mr. Govind, for that introduction. Without wasting much time, ma'am, over to you.
Thank you. Namaste. The topic today is revisiting Satyawati Tandon's Swiss Reverse case. The two topics that I shall attempt dissections on stem from the constant botheration in my mind regarding the injustice meted out upon the innocents by the banks. The mounting number of non-performing assets paved way for SARFAESI, which would provide an impetus to the banks for speedy recovery. What SARFAESI lacks is in the Department of Fundamental Justice. Fairness is expected in any law laid down. If the Act bestows on the bank officials powers that are normally conferred on the courts, then there's a requirement to balance the power by ensuring that safety measures are in place to protect the rights of the borrowers too. A broad spectrum section 17 does precious little to protect the borrower. It is only a belated remedy offered with stringent preconditions that does precious little to assuage the concerns of the panicking borrower. Section 17 entertains only issues pertaining to Section 13.4. It clearly absolves the bank of its failure to comply with the provisions that led to Section 13.4 notice by refusing to entertain a genuine grievance of a borrower that his Section 13.3a, which requires the secured creditor to consider the representations or the objections of the borrower to the notice issued by the secured creditor under Section 32, the DRT following the SARFAESI Act assists the banks in throwing the borrower onto the street even before it sells its property by way of an auction, which is post Section 13.4. The High Courts by way of writs tread carefully on such matters and refuse to entertain any SARFAESI petition by simply directing them back to the DRT, who has already sealed the fate of the borrower. So the banks, like hawks, are well aware of who approaches the DRT. They, with the assistance of these retired bank officials who have donned the black coat, pursuing a splendorous second innings in court along with other parts to a well-oiled machinery, swooped on hurriedly to arrange an auction so as to beat the borrower even before he attempts at the evasive stay of Section 14 notice. Now, the monetary preconditions ring the death knell. What follows is probably just the embalming process prior to the burial. To insist on deposit in cases where question of repayment to the banks would not arise at all is bewildering. Cases where a surety in good faith and belief in the humankind offers support to the borrower are cases in which the banks give the surety life lessons that trust and faith are non-existent. In several cases, the very sanction of the loan amount is questionable. The amount is given to the borrower, guised as a loan, which is shared in portions by all involved. What follows is a script out of the book, or shall I say the SARFAESI Act. The borrower defaults. The bank chooses to proceed against the surety as he is the easily available target. All this is done with complete knowledge that the law protects the deviants. Jointly and severally, a phrase that allows banks to proceed against anybody of their choice is more fully described as a bank and the borrower jointly enjoying the loan amount dispersed, and severally is when several of them go underground with the sole surety surfacing to face the SARFAESI proceedings. We are yet to evolve to a stage where only upon exhausting all remedies against the borrower can the banks proceed against the surety. This evolution is clearly unacceptable to both the legislator and the judiciary, as the intent is to hasten the recovery process. None of us sympathize with these habitual defaulters and borrowers who misuse and abuse the court process by pretending to adhere to the OTS scheme. They default on that too, bring about fresh OTS, revised schemes so as to delay and avoid repayment. It is such offenders who have probably ensured that courts do not sympathize with any borrower. Now, how did this SARFAESI come about? Recovery of debts due to banks and financial institutions, that is the RDDB Act, came to be enacted to enable banks and financial institutions to recover money from defaulting borrowers. The Act led to establishment of DRT, enabling the financial institutions to recover the debts. While granting powers to the tribunals, the legislator mandated that the provisions of the CPC are not applicable. For a few years, this process worked well, ensuring that cases involving the recovery of debts of banks and financial institutions are decided expeditiously. However, with the passage of time, the tribunal became synonymous with as of regular courts, and lawyers and representing borrowers used every possible mechanism and dilatory tactics. Now, the Narsimhan and the Andirjana committees suggested enactment of a new legislation for securitization and empowering banks and financial institutions to take possession of securities and sell them without the intervention of the court. The government of India accepted the recommendations of the two committees, and that led to the enactment of the SARFAESI. Little did the two committees realize that while recommending these changes, the banks would stoop to such debts. Contrary to the RDDB and the the SARFAESI has no provision requiring the tribunals to be governed by the principles of natural justice while determining the matters there. The SARFAESI Act empowers the DRT and the DRAT established under the RDDB Act to entertain matters under SARFAESI, and Section 34 ensures that there is no civil jurisdiction, that the civil courts have no jurisdiction. In this background, the decision of the Supreme Court in SATYAWATI Tandon plays a significant role. The decision clearly clarified two important aspects of law. First being that liability of the guarantor and the principal debtor is coextensive, and the creditor has the right to proceed against either for the recovery of the dues or realization of the decretal amount. And the second was with respect to exhausting of alternative remedy. Now, the SATYAWATI Tandon's case, after discussing the purpose of enactment of the SARFAESI, relying upon the judgments in Bank of Bihar and IIBI versus Biswanath Jhunjhunwala, the SATYAWATI Tandon's case held that the secured creditor can initiate proceedings under Section 13.2 and 13.4, as well as move an application under Section 14 against the guarantor without first initiating action against the borrower. It was also held that the liability of the guarantor and principal debtor is coextensive, and the creditor has a right to proceed against either for the recovery of the dues and the realization of the decretal amount. The Supreme Court primarily dealt with the importance of exhausting alternative remedies available in the SARFAESI before approaching the High Courts under 226. The Supreme Court, with reference to a large number of cases, clearly laid down that despite the fact that the rule of exhaustion of alternative remedies is discretionary in nature and not mandatory, the petitioner first ought to avail effective alternative remedies set out in the SARFAESI. So the Supreme Court, through the said decision, confirmed the priority accorded to the secured creditor and placed the guarantor and borrower on equal footing with respect to payment of dues. The Supreme Court failed to observe that it is the primary duty of the principal borrower to repay the loan. The guarantor could be proceeded against in the event of the bank being unable to cover the entire loan amount, even after diluting the assets given by the principal borrower. Ignoring this vital point has led to principal borrowers evading their liability and conveniently burdening the guarantors. This escapism requires to be fixed. What is required is focus on the recovery of the debts due to the banks. This is the only purpose for which that the RDDB and the SARFAESI came into force. Therefore, when the properties of the principal borrower are readily available to the banks to dilute and recover, giving them extraordinary powers to pursue whosoever they choose requires to be curtailed. The SARFAESI Act empowers the banks and financial institutions to enforce its rights over the security interests without the intervention of the courts. To ensure that financial institutions do not exercise this right guaranteed under the SARFAESI arbitrarily, an elaborate procedure is prescribed under Section 13, read with the security interest rules. Now, these rules, Rule 4 specifically, deals with the importance of protection and preservation of the movable assets which have been hypothecated to the secured creditor. Rules 6 and 8 detail the mode in which the movable and immovable assets need to be sold by the authorized officer. It is evident from the sequence of rules that the movable assets precede the immovable assets when it comes to attachment and recovery of the loan. Further, the rules clarify that a proper valuation of the movables and immovable assets need to be done by the authorized officer. With respect to immovable property, as per Rule 8, the authorized officer shall obtain valuation of the property from an approved valuer in consultation with the bank. Apart from these rules, the RBI has time and again issued master circulars, which are guidelines for the purpose of ensuring compliance of procedure laid down by the financial institutions. For instance, the RBI master circular in 2014 also, it specifically had guidelines with regarding to the personal guarantees of directors and other personnel of borrowing concerns. It specifically stated that personal guarantees of directors, it's stipulated that the bank guarantees of directors should be taken only when absolutely warranted. However, the financial institutions do not follow the procedure laid down in the Act, the rules, and the RBI guidelines, thereby infringing upon the rights of the debtors. In cases where the financial institutions do not follow the procedure laid down in SARFAESI or the rules thereunder, the debtor may approach the DRT or the DRAT, as the case may be, for the purpose of resolution. However, the remedy available under Section 17 of the SARFAESI Act is a limited one. That is, the appeal under Section 17 of the SARFAESI is available to the borrower only after losing possession of the secured asset. This is reflected in the decision of the Supreme Court in Stanchart Bank. This was in about 2013. The court, in fact, had observed, it can be noticed from the language of the proviso to Section 13(3)(a) and the language of Section 17 that an appeal under Section 17 is available to the borrower only after losing the possession of the secured asset. The employment of the word aggrieved by and taken by the secured creditor in Section 17(1) clearly indicates that the appeal under Section 17 is available to the borrower only after losing possession of the property. To settle not any doubt regarding the interpretation of Section 17, the proviso to subsection 3A of 13 makes it explicitly clear that either the reasons indicated for rejection of the objections of the borrower or the likely action of the secured creditor shall not confer any right under Section 17. Therefore, it practically states that you can come in only challenging Section 13(4). Whatever happens before that is not our concern. Now, the SARFAESI Act or the rules formulated thereunder do not address the situation when the secured creditors fail to comply with Section 13(3)(a) or Section 13(2). While the recourse under Section 17 is not available for violations under 13(2), 13(3), 13(3)(a), the High Court does not intervene when they are approached as a result of the SATYAWATI Tandon's case. The definition of the term security interest in the SARFAESI is probably one of the reasons for the court refusing to interfere. The issue with the definition of the term security interest has been presented before various high courts through a plethora of cases filed by the borrower whose secondary or collateral security were proceeded with by the financial institutions. In case of loans availed by companies, the primary securities are the assets of the company, and the collateral securities can be movable or immovable assets of either of the directors or shareholders or family members of the directors or shareholders or anybody else. From a plain reading of the term primary security, we can understand that it is a security which has been given as the main security for the loans available, and the collateral security is the additional security given in the event that the loans cannot be realized from the primary security. Therefore, the secured creditor has to realize the dues from the primary security first, and then, if needed, attach the collateral security. Now, primary security is that asset which is created out of the finance provided by the lender. For example, in a housing loan, the primary security is the house, which is being purchased out of the bank loan. In a cash credit limit, the primary security is the stock and the book debts, for which CC limit has been granted. In a term loan for machinery, the machinery is the primary security. The secondary and collateral securities taken by lenders is just an addition to the primary security to secure the loan. The loan agreements entered into by the secured creditor and the borrowers separately state that the prime security and the collateral security are different, because the loan agreements signed by the borrowers clearly state what the primary security and what the collateral security is, and they have separate columns for the same. However, this distinction is not made by the secured creditor during the process of recovery. For instance, in the Jharkhand High Court, they had the opportunity to deal with this issue of financial institutions proceeding with secondary security instead of going after the primary security. It was in the case of Niranjan Kumar. In this case, the presence of primary security of the borrower described in the sanction letter, though it existed, the bank chose to put on auction the collateral security of the petitioners who are just guarantors. Even the Allahabad High Court had dealt with a similar issue. The bank proceeded with taking over the possession of collateral security, which was actually the case of residential premises of one of the directors, instead of going after the primary security, which was the asset of the company. The company had taken the loan. There were assets of the company, but they chose to go against the personal property of the directors. Additionally, the director whose property was mortgaged was removed as the director. So what they do is, instead of going after the new director who's taken over in the company, they go after the erstwhile director who's given his personal property as guarantee. In both the cases, both the Allahabad and the Jharkhand case, both the courts refused to entertain the writ petitions in view of the decision of the Satyawati Tandon's case. One of the observations made in the Allahabad High Court judgment was, a bare perusal of the definition of security interest which has been referred above clearly states that security interest means right, title, and interest of any action whatsoever about the property created in favor of the secured creditors and includes any mortgage. Now, in the case of KSFC versus Narsimhan, this was a Karnataka matter that went on to in this matter, the issue of collateral security was offered by the guarantor. In this matter, the court said, observe, the rights and liabilities of a surety and the principal borrower are different and distinct. Apart from the defenses available to a principal borrower under the provisions of the Indian Contract Act, a surety or a guarantor is entitled to take additional defense. Such additional defense may be taken by a guarantor not only against a corporation, but also against a principal debtor. It basically said, in the absence of any express provision in the statute, a person being in lawful possession cannot be deprived thereof by reason of default on part of the principal borrower. Though this case protected the rights of the guarantor or surety, it was restricted to the State Financial Corporations Act. If this judgment could be interpreted in such a manner so as to extract the protection given to the guarantors and interpret the same under other acts, justice could be done. The SARFAESI Act and the Supreme Court have reiterated that the procedure laid down on the SARFAESI Act must be mandatorily followed. As a result, the power granted to financial institutions go unchallenged, wherein the liberty is widely utilized by the banks in connivance with interested parties to deviate from the purpose of the Act. Now, coming to the responsibilities of the bank officials. Bank officials have been greatly empowered and protected by the SARFAESI Act with the sole intention of ensuring that the banks are able to expeditiously recover public money. However, the same cannot be achieved by such bank officials in a manner detrimental to the interests of the borrowers or guarantors by conniving with interested third parties. The Supreme Court in the case of Madhya Chemicals, while determining the constitutional validity of SARFAESI Act, made reference to the concept of lender's liability. The court's attention was brought to this concept of lender's liability in the backdrop of a US court decision. Now, in Madhya Chemicals, the court specifically stated, whatever be the position, however, it cannot be denied that financial institutions, namely lenders, owe a duty to act fairly and in good faith. This is also the basic principle of concept of lender's liability. It cannot be one-sided affair, shutting out all possible reasonable remedies to the party, namely borrowers, and assume all drastic powers for speedier recoveries of the NPA. Possessing more drastic powers calls for exercise of higher degree of good faith and fair play. The borrowers cannot be left remediless in cases where they have been wronged against or subjected to unfair treatment, violating the terms and conditions of the contract. Now, in addition to all of these privileges given to the secured creditors, the Act specifically grants immunity to the officials of the secured creditor. Section 32 of the SARFAESI Act provides complete immunity to the secured creditors and its officers in discharging their duty as prescribed by the Act. So Section 32 provides protection to the action taken by the secured creditor or any of its officers, which is in good faith against any suit, prosecution, legal proceedings, whatever shall lie against them. Now, the Supreme Court had an opportunity to go into this aspect of criminal proceedings initiated against the bank official in the case of Virupaksha versus State of Karnataka. The Supreme Court in this matter, criminal proceedings were initiated against the bank official before the jurisdictional magistrate for having colluded with purchasers to realize basically what they had done is they released only 90 lakhs of the sanctioned 2.6 crores to the borrower. The investigation conducted by the jurisdictional police also revealed that the accused persons with conspiracy and in collusion with each other cheated the borrower by not releasing the amount and caused economic stumbling block and sold the mortgage property to one of the accused. The High Court in Karnataka had deemed it necessary that investigations should be proceeded with against the bank officials and refrained from quashing the proceedings. Though the allegations of the fraud committed by the bank officials was forthcoming in the investigation, the Supreme Court found it necessary to intervene and exercise extraordinary powers and quash the criminal proceedings. The court noted that the SARFAESI proceedings, as contemplated under the Act, were followed by the officials and that recourse was available to the borrower, which in this case was exhausted. Further, the reference was made to aspects of defense of good faith and public good. It was contended that the same was to be proved by way of adducing evidence. The court brushed aside the contentions by stating that the aspect of good faith could be examined in the proceedings provided under SARFAESI Act, and in view of the fact that the officials could not be exposed to criminal proceedings on count of breach of good faith before the investigation officer would not be justified. In this regard, the bank officials, who are to be accountable to the public, were granted a free pass to escape the rigors of the law. This judgment has further fortified the existing arrogance of the bank officials, giving them liberty to act arbitrarily and take protection under Section 32 of the SARFAESI Act. The court also made observations with respect to Section 32 of the Act, which provides immunity to the actions of the officers of the secured creditor done in good faith as per the Act. The blanket immunity provided to the officers of the secured creditor without considering the possibility of a genuine case of default by the borrowers, it's often overlooked. While the Supreme Court in this matter was of the opinion that the borrower could adduce evidence against the officer before the DRT, what the court failed to realize was that the borrower who had lost it all and his properties being sold to a third party, he would not be in a position to deposit a ridiculously large amount before the DRT so as to pursue a lost cause and a case. The Madras High Court in Shiba Phenomenal dealt with the issue of fraud committed by the bank officials while following the procedure under SARFAESI and in connivance with interested third parties. The court strictly remarked against the practice of bank officials for non-compliance of mandatory provisions of the Act, and also on fraud, lack of fair play, bona fides, etc. The aspect of greater responsibility imposed on the bank officials was looked into by the Supreme Court in Eureka Forbes case, Eureka Forbes versus Allahabad Bank. It was observed in this matter, arbitrary action or irresponsible action would normally result in dual hardship. Firstly, it jeopardizes the interest of the banks and public funds are wasted, and secondly, it would affect the borrower's interest adversely, provided such person was acting in bona fides. It also dealt with principle of public accountability, that it is applicable to such officers and officials with all vigor. Now, the legislative object of expeditious recovery of all public dues and due protection of security available with banks to ensure repayment of debts cannot be achieved when the officers and the officials of the bank act in such a careless manner. There's a public duty cast upon all of these officers to act fairly, transparently, and with a sense of responsibility to ensure that the recovery of public money and dues is there. The adverse impact of lack of accountability in discharge of public duties can result in varied defects, not only in the decision-making process, but in the decision as well. Every public officer is accountable for its decision. Now, in order to deal with the issue presented by the decision in the Satyawati Tandon's case, the legislator and the courts could take into consideration certain important changes that might be required. The changes that are required are, even though the Act does not make any distinction between collateral and primary security, the bank issues loan sanction documents demarcating primary and collateral, thereby creating an illusion of collateral security being an option available after recovery of the primary security is exhausted. Now, the banks should be made to refrain from executing such documents and create charge over properties which are unnecessary, while the value of the primary security would be sufficient to cover the loan amount and interest in case of default. When proceedings against possession of secured assets under Section 13(4), the movable assets must be first considered. Next would come the assets of the borrower, and finally that of the surety. Remedies must be made available to allow the borrower to approach the court when there is non-compliance of correct procedure adopted while resorting to Section 13(2) and failing to grant an opportunity under 13(3)(a), since such a remedy is not available under Section 17 when you go on an appeal. So instead of proceeding against the primary security, the assets of the company, the banks resort to taking over possession of collateral, which in most cases residential premises of one of the directors. In many situations where I have seen, elderly couples, aged people are thrown out on the streets and their properties have been taken over. It's a sad state of affairs. The banks should be directed to first proceed against the primary security, and in case the amount sought to be recovered falls short of the amount, only then the bank should be allowed to proceed against collateral. Banks should not be permitted to proceed against the surety and the guarantor as a first resort, especially cases where a reasonable OTS proposal has been given by the principal borrower. The bank should consider accepting the money proposed, and the balance amount for recovery, if any, can be granted as a loan to be paid in installments. Only in cases where there is no source to recover the money from the principal borrower should the banks be permitted to move against the guarantor. Now, the High Court in several cases have expressed their inability to offer any protection as a result of the Satyawati Tandon case. The High Courts have said that their hands are tied, and in some cases have fully concurred with the views of the petitioner and are yet unable to grant protection, as the High Courts have been specifically directed not to entertain matters pertaining to SARFAESI. Now, the Satyawati Tandon's case was in the year 2010, Standard Chartered 2013 or so, which showed glimpses of relief similar to Madhya Chemicals, yet failing in the end. Now, Madhya Chemicals and Stand Chart, they seemed like winds of change, though falling short in the operative portions. An earnest attempt at re-examining the anomalies is suggested, truly believing in the principles of natural justice. Now I shall move on to Insolvency and Bankruptcy Court, that's the IBC, where we will deal with the Swiss Ribbons case. Now, the Insolvency and the Bankruptcy Court was enacted mindful of the concept adopted by the UK bankruptcy laws, and that is the creditor is made in charge of the management of the corporate debtor, that is the company that's in debt. In our system, as soon as the CIRP process, that's the corporate insolvency resolution process, is initiated as against the corporate debtor, an interim resolution professional, who's normally a CS, is conferred with powers to collate and verify the claims of creditors of the corporate debtor, and after the committee of creditors, after that, is formed. If the IRP, that is the interim resolution professional, is confirmed by the committee of creditors, the IRP is assigned the role of the RP, that's the resolution professional, or the one substituted by the COC upon the approval of the adjudicating authority, which is the NCLT. Now, the resolution professional, the management of the day-to-day affairs of the company, immediately upon admission of the matter before the NCLT, is handed over to an individual. And this individual, as an IRP, holds vast and extraordinary powers, which is open to misuse more often than not. Though the code and the rules confer upon IRP range of powers to collect and verify the claims of the creditors, the power of the IRP is a restricted one. In practice, the IRP cannot reject claims per se, but has the power to deny verification of claims submitted by the creditors of the corporate debtor due to reasons such as limitation or late filing of claims or improper format of the proof of debts. In the combined appeal filed before the NCLAT in the matter of Prasad Gempex or Shrey Infrastructure, the question that arose for consideration was whether the resolution professional had the jurisdiction to decide or reject the claim of one of the financial creditors or the operational creditors. A similar issue fell for consideration before the NCLT in Dynapro. The NCLAT, by its judgment dated, I think it's sometime in 2019, they held that the resolution professional had no jurisdiction to decide the claim of one or other of the creditors, including financial creditors, operational creditors, secured, unsecured creditors. The power of the resolution professional also fell for consideration in the Swiss Ribbons case. In the said judgment, the Supreme Court held that resolution professional had no adjudicatory power. The resolution professional, that's the RP, had to vet and verify the claims and ultimately determine the amount of each claim. As opposed to this, the liquidator in the liquidation proceedings under the IBC has to consolidate and verify the claims and either admit or reject such claims. Even though the Supreme Court has categorically made it clear that the RP does not have unrestricted power, he or she is merely an administrator under the control of the Committee of Creditors. There have been several instances where the RP has rejected claims of the creditors on the grounds apart from the ones discussed earlier. The only remedy available to the creditor whose claims are rejected is to file an application under Section 65, which is like our 151 of CPC, before the jurisdictional adjudicating authority, the adjudication of which is time-consuming and leads to further difficulties. However, the issues arise when the resolution plan is approved by the adjudicating authority during the pendency of the rejected claims of the creditors before the NCLT. For instance, in Santosh Vasantrao, this was dealt with. A resolution plan was already passed by the Committee of Creditors, while the challenge to the rejection of the claim of one of the creditors had not yet been adjudicated upon by the NCLT. So the Supreme Court, in the Committee of Creditors in SR Steel matter, they held that only the claims acknowledged in the resolution plan were to be considered, that they are in existence, and by virtue of the same, all claims pending before the NCLT, such as the case of that Santosh Vasantrao case, at the time of approval of the resolution plan, would stand extinguished. Therefore, resolution plan goes on over here, it's completed, and here are some of the creditors, as a result of the IRP refusing their claims, are still fighting that battle. The relevant portion of the decision of the Supreme Court in the Committee of Creditors in SR Steel, basically it states that a successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him have been accepted. And this would amount to a Hydra head popping up, which would throw into uncertainty amounts payable by a prospective resolution applicant who successfully takes over the business of the corporate debtor. All claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what is to be paid in order that it may be maybe take over and run the business of the corporate debtor. What basically it said in SR Steel is that it has to be, the process has to be completed. And once a resolution plan is accepted, the person who's taking over the debts and the liabilities and of the company should know what he is in for. And therefore, you cannot accept claims subsequently. Now, in order to protect the interests of the successful resolution applicant, the genuine claims of the creditors are set aside or they're extinguished by merely getting the approval on the resolution plan submitted by the RP before the adjudicating authority. The primary reason as to why the creditor whose claims are rejected is brought to that position is due to the arbitrary exercise of power by the RP. Amongst the important duties of the IRP is in receiving and collating of all claims submitted by the creditors and constitution of the Committee of Creditors under Section 18. Therefore, it's pertinent that the IRP or the RP, as the case may be, exercise its power with utmost transparency and in the interest of all stakeholders of the corporate debtor. Therefore, it's necessary and important that the exercise of the powers of the IRP be supervised. In the present framework, the apprehension of the independence of the RP becomes irredeemable. In a situation where the conflict of interest pertains to the financial creditor having majority voting share in the COC. In other words, despite the prescribed disclosures, a creditor having majority of voting shares in the COC may appoint a non-independent RP, rendering the disclosures meaningless. Since the RP is a facilitator of the CIRP process and is guided by the decisions of the COC, existence of any such prior relationship with the creditor with majority vote sharing may hinder the CIRP and turn it into a mechanism to benefit such creditor. Therefore, impartiality and independence of the RP forms the crux of the effective and successful CIRP. Now, reducing excessive rejection of claims, because most often claims are rejected by several creditors. Supreme Court in Swiss Ribbon's case held that the resolution professional does not have quasi-judicial powers, but merely administrative powers. So far, so good. This position was expanded in Navneet Kumar versus BHEL. The NCLAT in this matter held that the resolution professional cannot reject a claim without taking the evidence which substantiates the claim. Due to the lack of quasi-judicial powers, every claim which requires judicial determination in order to be admitted has to be decided by the NCLT. Thus, any creditor with a rejected claim wishing to challenge that rejection has to mandatorily approach the adjudicating authority, who would make a de novo review on the validity of the claim, thus increasing the caseload on the adjudicating authority and thereby delaying the admission of the claim. So while the resolution professional has to verify each claim within 7 days of the receipt of the claims, neither the IBC nor the regulations under the IBC prescribe a duty on the adjudicating authority to decide the challenge to the rejection of the claims within a specific time period. So here is a case where within 7 days he collates, accepts, rejects, puts it forth, COC goes on with the resolution plan if there is some party there. Meanwhile, this creditor whose rejection of claims is pending, he's challenging it and he's waiting for his turn. Section 12 of the IBC directs that the CIRP shall be completed within 180 days, and the time period may be only extended on an application by the resolution professional after directions from the Committee of Creditors, COC. A creditor whose claims has been rejected by the resolution professional would not be a part of the COC and thus would have no say in requesting the adjudicating authority to extend the time period for the CIRP in order to accommodate the time required by the adjudicating authority to decide a challenge to the rejection of the claims. In the United Kingdom, the insolvency rules tackles this problem by allowing the administrator to postpone the distribution of the dividends. That is, it mandates that as long as a petition to determine the validity of the rejection of claims lies in a court, the administrator cannot proceed with the distribution of dividends. Such approach attempts to put all creditors who have made claims to be on an equal footing, and thus no creditor is unfairly prejudiced from the rejection of claims. The Committee of Creditors, they are the ultimate authority. They have to approve or reject the resolution plan which is placed before them. Hence, the RP primarily discharges the administrative functions and works in accordance with the provisions of the IBC and the applicable regulations made by the IBBI for overall benefit of every stakeholder, including the COC. The constitution of the Committee of Creditors plays a very significant role for the management and resolution of the CIRP process. As a thumb rule, every act of the RP in conducting day-to-day business of the corporate debtor during the CIRP must have clearance from the COC. The COC remains in charge of the acquisition of the assets and the liabilities. The RP, on the other hand, is primarily responsible for the day-to-day operations of the corporate debtor company to maintain it as a going concern. Now, the COC stays at the helm of the affairs, even where there are proceedings, that's the transition out of the CIRP to the stage of the resolution or liquidation. As per section 34, subsection 4, the COC must approve the proposed resolution plan by at least 66% majority after considering its feasibility and viability. Once the COC approves the resolution plan, the RP is bound to place the resolution plan before the NCLT for due approval under section 31. Now, the power is very limited there. Once the NCLT approves the resolution plan as approved by the COC, the said resolution plan becomes binding on all stakeholders. The constitution of the Committee of Creditors is in accordance with the claim of such financial creditor, and has against the corporate debtor, and thus violating rights of the financial creditors are assigned according to the financial debts owed to such creditors. What happens if majority of the debt is due to the operational creditor? In such cases, operational creditors would be deprived of voting rights despite collectively having lent a lot of the debt amount. Operations of the business are the operations, that is the operation creditor's business, are as important as the financial creditor. Denying the operational creditor their right to vote is not justified. Though the resolution plan can be proposed by either a financial creditor or operational creditor, the same needs to be approved by the committee, which comprises most often than not only financial creditors. The rights conferred on operational creditors are subjective as opposed to the financial creditors, which gives financial creditors a complete monopoly over the CIRP. While the banks proceed to divest their bad debts to asset reconstruction companies at ridiculously low amounts, the same is not followed when the OTS scheme comes under the SARFAESI Act. Now, the OTS scheme is quite often rejected. They have several parameters, but when they sell their bad debts to the reconstruction company, the no process is followed. All small-time borrowers are reminded that the banks cannot go beyond a prescribed limit of the valuation when they offer the OTS. This again reeks of injustice. While the OTS policy stipulates stringent conditions to consider an OTS, it is not the same when bad loans are divested to the restructuring companies. There have been instances where the asset reconstruction companies established under the SARFAESI acquire the NPAs of the financial creditors of the corporate debtor and become part of the COC. Connivance with other financial creditors who are part of the COC ensure that the assets of the corporate debtor are acquired at discounted prices, such the assets of such assets which are submitted by a resolution plan fabricated by interested parties. Now, significantly, the IBC does not subject the resolution plan per se to judicial scrutiny, and the limits of judicial review have been circumscribed to the parameters in Section 30. The COC possesses exclusive access to negotiations and retains the right to take the final call in dealing with the business decisions. The decision of the Committee of Creditor and SR Steel matter talks about the role played by different players in the resolution framework. The decision dilated on the role of the COC, the NCLT, and the NCLT. The Apex Court they concluded that the limited judicial review available with the adjudicating authority can be considering important parameters such as maximization of assets value, ensuring that stakeholders' interests are adequately factored in, etc. Now, the Supreme Court has clarified that the role of the RP is not adjudicatory but merely administrative. However, owing to the very nature of the functions and duties carried out by the RP, a biased administration of the resolution process is an eventuality. Let me put the problem on hand by way of simple examples. There are two scenarios. One where the debtor company is genuinely unable to pay its debts. Creditors move the NCLT. Case is admitted. Several creditors before the NCLT, both operational and financial approach. Banks who lent to the debtor company get rid of their bad debts by giving it away to the asset reconstruction company at a heavily discounted amount. Accountability on that aspect is another issue altogether, which should require a significant amount of time. Now, the ARC then plans and decides to constitute and occupy the COC exclusively by ensuring that the IRP decides on claims of other creditors. The claims of other financial creditors are either rejected or demoted to the place of an operational creditor, thereby ensuring no seat at the COC. This act of the IRP is challenged before the NCLT and based on the outcome, more often than not is delayed and is then before the NCLAT, by which time the COC has hastily convened meetings, accepted a resolution plan placed by none other than the person or company that controls the reconstruction company. The funds of this ARC is derived by the controlling party. Now, therefore, the ARC often is a front for a party that proposes to acquire, say, 1,000 crore company, 1,000 crore worth of assets of land, factory, machinery. They will try to acquire this for 1/4 the cost. The bad debts of the banks have been taken over at a ridiculously low distress transfer, wherein, say, about 225 crores is now the ARC's claim. So the ARC sits in the COC, gets the RP to accept a couple of negligible financial creditors so that they put up a show of fairness, thereby ensuring that the claims of overall don't cross about 250 crores. Now, the resolution plan is then a knight in shining armor, coming to the rescue of the creditor, detailing out the restructuring of the company and taking over the assets and liabilities with a phased plan of repayment of this 250 crores. What is then overlooked is how this company that comes up with a plan is benefited by nearly 750 crores. Another scenario is a loan to the tune of several crores is taken by a certain party, pledging very little as security, clearing the loan process by whatsoever means available at his disposal, and then he defaults very conveniently. Additional loans are then given as restructuring. Loans remain unpaid. Banks declare NPA. So as to protect themselves from any inquiry, the banks proceed to nonchalantly file a criminal case against the borrower. Now the CBI steps in, since large amounts are then involved, then begins the trial against the borrower. As this is on, the creditors, including the overzealous banks, move the NCLT, while the investigation agencies preliminarily establish a money laundering exercise. The same does not deter the parties from continuing with their heist. The same process as in scenario 1 plays out, where banks transfer their debts to the reconstruction companies. The ARC is funded by the very same party that defaulted in the same place, takes control of the COC, clearing the way and the path for Act 2 Scene 2 to be enacted. In all of this, the legal system might just be able to establish the fraud played by the borrower, but in all of this, the liability of the bank is never questioned. None of what I have stated so far would ever take place if the bank adopts stringent measures during the approval of the loan. It is often a classic case of a middle-class man repeatedly being punished for taking a small loan, business taking a hit, bank attaching the house he lives in, auctioning it to one of their people, with a fair amount being distributed to all of them who assisted them in this unholy nexus. There are several other ways that are available to them to beat the system, and the bank officials excel at it. Tweaking of the Swiss ribbons case and bringing about changes in the selection process of the IRP or the RP, qualification criteria altered, 3-step process in accepting the claims in a transparent and accountable manner, constitution of the COC, transparency in entry of the reconstruction companies, funding details to be furnished. These might provide the much needed relief to the deserving litigants. If funding details of the asset reconstruction companies are produced, then we are going to know where it came from. Now, coming to the Swiss ribbons case, the Supreme Court in this matter upheld the constitutional validity of the IBC. Several writ petitions and several leave petitions were filed before the Supreme Court challenging the constitutional validity of the provisions of the code. The Supreme Court, after analyzing the provisions of the code, held that classification of creditors as financial and operational is not in violation of Article 14, and financial creditors are from the very beginning involved with the assessing the viability of the corporate debtor, and therefore they engage in the reconstruction of the loan and as well as reorganization of the debt business, thus ensuring maximum recovery for all creditors being the objective of the code. Financial creditors are clearly different from operational creditors. This is what the Swiss ribbons case says. The judgment discussed classification between financial creditor and operational creditor. Validity of 12A of the code was upheld by virtue of the applicant, by which the applicant is allowed to withdraw the CIRP application post-admission if the COC by 90% of vote approves the same. Resolution professional has no adjudicatory powers. The validity of the ineligibility criteria of the resolution applicants under 29A was upheld. Validity of FT3 was upheld and the ranking of the financial creditors was placed in a higher pedestal in view of the fact that the payments of their debts would infuse money back into the economy. Resolution professional had no adjudicatory powers, and it was argued that the granting of unbridled powers of adjudication to a non-judicial authority under the code is violative of the basic aspects of the dispensation of justice. Contrary, it was also argued by the center that the exercise of powers were not adjudicatory. It was only allowed to collate information. Even when the IRP exercises such powers, he exercises the same in his discretion, administratively, which is subject to supervision of the NCLT. The court finally concluded that resolution power professional is given administrative powers as opposed to quasi-judicial powers. The RP is a facilitator and that he is under the supervision of the NCLT. Now, the changes that are required under the code and the regulations, similarly to that of Rule 14 of the Insolvency in England, a provision has to be inserted in the code, in our code, where during the pendency of the adjudication of rejection of claims of the creditor, the entire insolvency proceedings be stayed, or at least a mandatory time period be fixed for determining the application challenging the rejection of claims. If ARCs are to be made part of COC, they must be directed to disclose information of their funding from the acquiring NPAs, from the financial creditors of the corporate debtor, and also place before the NCLT if they are to take part in the COC. The IRP or the RP must be brought under the supervision of a certain authority wherein the acceptance or rejection of claims are done in a transparent manner so as to ensure that the IRP, RP do not perform their functions in connivance with either the IRC or interested parties, including corporate debtors sometimes. The resolution plan must be approved by the COC only after the challenge of the rejected claims have attained finality. If not, the resolution plan submitted by the adjudicating authority must be accepted subsequent to or subject to the final determination of the rejected claims. Now, Section 29A was vehemently argued in Swiss Ribbons and it came to be upheld. This is the criteria of the resolution applicants. If the same stands defeated by such backdoor entries, now the reason 29A was upheld was that we should not allow any of these promoters to get back into the COC. That is why 29A was upheld. But if the same stands defeated by backdoor entries, when under 29A, even those promoters who had nothing to do with the rot in the debtor company and were also kept out while restructuring, is it not necessary then to seek the funding financials of the restructuring companies, as they are sometimes the front for the erstwhile promoter? While Swiss Ribbons holds the economic activities must not be meddled with unnecessarily, and economic regulations require judicial self-restraint, it is absolutely necessary to delimit the self-limitation when the act is abused repeatedly. Just by way of 248A that came into force subsequently, the continuous process of improving upon the act is the reason that such anomalies have been highlighted so as to bring forth the ground realities. 248A came in subsequently when they realized that there are certain mistakes that need to be corrected. Therefore, if we are able to put forth the anomalies, maybe they could bring forth other amendments that could come by. The judgment of the Swiss Ribbons in the end says, defaulters' paradise is lost, and in its place, the economy's rightful position has been regained. If we are to go by John Milton, then paradise is regained by recognizing the ill effects of Satan. It is only the judiciary that looks up to correct the mistakes, quashing of certain provisions or suggesting amendment of the procedure of guidelines. The need of the hour is a revised Satyawati Tandon and Swiss ribbons. I shall end my talk here. Thank you. Back to you, Trivikram.
Thank you, ma'am. That was a stupendous presentation. Now, can we move on to the Q&A session, ma'am?
Sorry? Yes, yes.
We now move on to the Q&A session.
Sure, please.
Thank you. Mr. Govind, can we start with your questions, please?
We have some questions on Zoom. One is Ram Jaluka sir is asking, madam, if the account is classified as fraud, how assignment to ask can take place?
Could you, sorry, Govind, could you repeat it?
I'm sorry, ma'am, if I was too fast. Ram Jaluka sir is asking, madam, if account is classified as fraud, how assignment to ask takes place?
How assignment?
To ARC, assignment to ARC takes place. I'll ask Mr. Ram Jaluka sir to please how the assignment ARC will take place now. If account is classified as fraud, how will assignment to ARC take place? Assignment to ARC.
All right. Okay. So if something is classified as fraud already and it is established, it's a different thing altogether. Now we're talking generally when they try to get rid. All right. So you're talking about if there was a fraud in the borrower. No, that is a separate process and a criminal proceeding goes on as against the borrower. But no action is taken against the bank that there was a fraud played by the bank also in lending to that borrower. So the fraud is only established as against the borrower. You get me? So that continues separately, but the banks are free to get rid of their bad debt at any possible time. Only what you are talking about is if in the case it's established that there was a fraud on the part of the bank also, then maybe they cannot. But most often, I have not heard of cases where it's been established that banks have also been part of the fraud. If you look even at the Malia case, how did he get such bank loans? Several of them are just corporate loans. There is no secured creditor. Most of the banks in the Malia case are not secured creditors. So none of the banks I see have been held liable for this. Malia faces prosecution, but tell me which bank has faced any prosecution in having lent him money without taking sufficient guarantee?
Okay. That's actually, I hope Mr. Ramdulkar that's answered your questions. Moving on, there's a question from Ms. Minesh Khanna. He's saying that also these insolvency professionals, the ones that are appointed, what happens is many times one individual is appointed for money companies, and sometimes it happens most of these people aren't very knowledgeable. This is from Bombay High Court, he's from the Bombay High Court practice. This point is that these people that they're being hired, also we have the procedure, there isn't much, that they can do or they actually do for the good.
They might not be very knowledgeable with respect to the IBC. I'm not too sure, but most of them are, they're all company secretaries, so they're extremely good with the numbers. But if you look at it, basically they're all chosen very conveniently. And more often than not, you see them siding a particular individual, either the secured creditor or the main financial creditors. Sometimes they even assist the debtor, giving them, though the Swiss ribbons case curtails their powers, unfortunately we see it on a day-to-day, we have experience wherein several of our claims are rejected. He directly assumes the role of a judge, flatly refuses and says you're not a financial creditor, sometimes says you're not a creditor at all, refuses to accept their claims. They have to keep serving them several copies stating these are the proofs. He said, and then they go into detailing. Swiss ribbons clearly states that you cannot go into details. You can only collate. Then when you can only collate, they do go ahead. So you might find some, as you say, not so knowledgeable ones. I think then you've been fortunate because most of them are extremely sharp, as I say.
So there was this one recent reporting, ma'am, last year in 2019, where one person was appointed 70 times. I think so 60, 70 times. There was some case or something like that. It came under the scanner. It was looked into. So, it is a problem because there are lots of fees and everything associated with this that people do, enrich off. So that is the reason.
Correct. So you see, the NCLT has the list of all of them. I feel that we might have to do this weeding out of these corrupt ones and keep a good list of them. Actually, NCLT has noted that sometimes when they remember the names, in fact, even NCLT Bangalore, they do say, no, this person already has 2-3 in them. I don't think we should give it to them. Let's give it to somebody else. So when they are aware of it, they see to it that it doesn't happen. But what happens is that even assuming that you choose a person that you don't know, getting to know him doesn't take time, very honestly.
True. Okay. Definitely not. And there are more questions coming, but there are also questions coming on the other side. I'll just hand it to Mr. Arora. Mr. Arora?
Yeah, thank you so much, Govind.
Yeah.
Thank you so much, ma'am. I don't know a lot about IBC. I think most of the people here would know more than me. But I think I was understanding things, and it was a really clear, graceful, and elegant presentation that you delivered. Thank you so much.
Thank you so much.
Thank you, and thank you, Vikram sir, for helping us across to ma'am. So I'll ask
that credit should go to ma'am because she has agreed in between her very busy schedule. I know it's a lockdown here, but nevertheless, she is working from home. But despite that fact, she has agreed and she has delivered this presentation. So that credit should go to ma'am.
Oh, not at all. It's a passionate subject. So
honestly, I also said this subject is very hard, very technical. It requires to have immense knowledge about the corporate sector. But ma'am just explains it so plainly and so well. I really appreciate it.
Thank you so much. Thank you so much.
Can I ask
Raghav,
a question?
Sorry?
Yes, please. Raghav, you can go ahead with your questions. I have a couple of them. So,
Thank you. Ma'am, this is a question from Uday Shankar Associates we've just received. Can the secured creditor stand outside IBC proceedings and want to pursue his remedies under SARFAESI without becoming a part of the COC as formed by the resolution professional?
Well, they can go ahead with the SARFAESI, but what happens is that if before the NCLT, they come up with a resolution plan and then they accept it, then it means that the debts are taken over by another company altogether. So then you really don't know what's happening. So it's always safer to be part of the NCLT. You can parallelly continue before the SARFAESI because it doesn't prevent you.
Okay, ma'am. Another question from Mohsin Kadri.
Mm-hmm.
He wants to ask, in case NPA declaration is in violation of RBI Master Circular and the bank resorts to SARFAESI, where lies the remedy as the basis and foundation of issuance of notices under the Act remains unlawful by secured creditor?
This is the very reason I've had this talk today, because there is no remedy, unfortunately. Whether it's the way they've gone about declaring it as an NPA, whether they've gone about the 13.2 notice wrongly, or whether they've not even given you an opportunity to file your objections to the 13.2 notice under 13.3. All of these violations, unfortunately, have no source for us to go to, because the High Court says no, go to DRT. DRT can accept under Section 17 only after 13.4 comes into place. So honestly, so far, we have nowhere to go to. And even the Supreme Court in Stanchart and other matters, they've really not looked into the difficulties of the persons. And that is why the talk today on this aspect. So to answer your question, you'll have to move the High Court and convince the High Court that there is no other alternative remedy available to you and that the High Court has to intervene directly.
Thank you, ma'am. Another question is from a student, Shine. She wants to ask, ma'am, if I could ask who's a resolution professional.
Sorry, if I could ask?
Who's a resolution professional?
Okay, so a resolution professional is a person who comes into the framework when the IBC CIRP process is initiated. The moment a case is admitted before the NCLT, immediately they choose a person called the interim resolution professional. Now, this person is a company secretary. There's a list of them that are qualified, that the list is there with the court. The moment they are appointed, what happens is when the matter is admitted, it means that the debtor company ceases to exist. The IRP takes over the role and functions and operates the company. So the company against whom a creditor has moved and the case is admitted, the IRP takes over the company and manages the company. For example, I owe money to X, X moves NCLT, gets the case admitted, basically proving that I still owe him money and I'm unable to pay my debts. The moment it is admitted, the IRP comes and takes over the role of running my company. In fact, I can't even sign checks after the day the matter is admitted. So if the company has to run on a day-to-day basis, the IRP decides as to how it should be run till such time that the process continues. This is their role. Subsequently, all others who have claims against this company that is defaulted, IRP has to collate all their claims, accept or reject those claims, and then it is decided as to how many claims are there. The COC is formulated by the financial creditors. The operational creditors just stay there and wait. If at all some trickles come down to them, then they might get a little bit of the crumbs. But otherwise, the COC decides based on a group of financial creditors. So the IRP decides all of this, RP subsequently.
Wow. Thank you so much, ma'am. Another question from Mr. Kumaraswamy. Madam, in case if the bank has followed all proper procedures, have taken prime security and not collateral security, the borrower is at fault but needs time to settle the debt. Is there any way out?
The banks are bound to consider your offer of an OTS. There are also these rules, the RBI guidelines are also there, especially for MSMEs, which specifically states that if a person is unable to pay their debts, the banks have to constitute a committee. That committee goes into what kind of business you're in. And they are going to try to formulate a scheme whereby if they give you additional funds, would they be able to revive your company? They're supposed to do all of this, which they don't conveniently. Next, if it comes to a stage that they think that revival is impossible, they should come out with a good alternative, an OTS offer, and that should be formulated in such a manner that the bank also gets its money and this person is also not deeply affected. This is the only way that they could go about it.
Thank you so much, ma'am. Vikram sir, do you have any questions at your end?
Yes,
I think I'm done.
I have a couple of them, ma'am, by Mr. Vivekananda. The question is, Section 29A was upheld in Swiss ribbons. Section 240A was introduced, given exemption under Section 29A to MSMEs to enable those promoters to submit resolution plans. Has this actually served any purpose?
Not really, because what happens is that MSMEs, you've given that the liberty, but subsequent also amendments on the minimum amount also prevents a lot of them from moving. Also, this issue of there is also a regulation which says that an operational creditor should at least have about 10% of the value in debt to be part of a COC. So quite often you don't have the 10%. But yes, it has partially assisted some small-time operators to at least, just slide their foot inside the door when it's shutting. That's about it.
Right. Thank you, ma'am. Next question is by Mr. Nitish. Has the primary of COC led to the downside effect of most of the debt claims ending in liquidation?
Has the?
I repeat, has the primacy of COC led to the downside effect of most of the debt claims ending in liquidation?
Well, we can't speak in general, but yes, the fraud committed in getting the seat in the COC quite often does affect, because there are so many of the genuine creditors who are left out and interested parties get to clear their claims and go out. So these are things that need monitoring, honestly.
We have two questions by Mr. Surya Kumar, but I am not very sure if it is correct, but I'll just read it out for you.
Sure.
If the amount recovered from the sale of property is not sufficient to
Mhm.
cover the loan, can the
Mhm.
bank officials' assets be attached? I'm
Bank
afraid if
of-
it is correct.
uh,
And
I
his
wish,
second
I
question is
wish
the
that
first.
could be done, but obviously not. See, that's the thing. Section 32 of the SARFAESI Act completely, insulates them from any kind of action because everything is good faith. I hate doing the inverted commas with my, my fingers, but that's ridiculous. Saying good faith, because anything can be good faith. How do you go about proving it? You can't go run a trial in DRT because first you are asked to deposit, 25% minimum. How are you going to pay 25% minimum when you're actually not even liable sometimes? Because the bank should have already recovered it. They're proceeding against you on interest, which is not workable. So who is to decide all of that? This issue of deposit of amount, to go on an appeal before the DRAT, you have to deposit 50%. Nobody has that kind of amount. So even sureties don't have that amount. So it's just not right.
Second part of his question is, can the bank sell the security property of the NPA loan well before the loan period ends? That is, loan sanctioned for 10 years become
Mhm.
NPA after 3
Mhm.
years.
Yes, the moment it's declared NPA, they can start their process. So yes, they can proceed against the guarantor.
Thank you, ma'am. I'm done with my questions. I think, Mr. Govind, we have a couple of questions in the chat box. If you could, I request you to read out those. I can see one by Mr. Prajwal. So can you pick up those questions?
Prajwal, okay, from Prajwal. Yes, ma'am. The question is by Prajwal G, sir. Does the money advanced by a home buyer fall under the definition of financial creditor on a plain reading?
Well, fortunately, yes, they've all been classified as financial creditors. So that's a breather for a lot of home buyers. Yes.
So I think Prajwal, sir, that's the answer. Then we have one by Mr. Kumar Swamy VN, sir. Madam, in case the bank has followed all proper procedures, have taken prime security and not collateral security, the borrower is at fault but needs time to pay the debt. Is there any way?
I think we've
that was
taken
read
that
out.
already.
Yeah, that's just working it out with the banks, just ensuring that they don't proceed with 13.4. Keep them in your good books.
Okay.
Ensure that you try to come out with some kind of an OTS offer. And that is why I have proposed one of the changes that even when you come out with an OTS scheme, if they do have a certain amount that they could pay, the bank should take that and the balance of the amount, start a new loan process to recover that. So it's a win-win situation for everybody.
Okay, yes, on that. Mulgari Srinivas says that Madam IBC jeopardizes operational creditors. Why?
How well in the Swiss Ribbons
IBC jeopardizes operational creditors. Why?
Yeah, but in the Swiss Ribbons case, this was dealt with extensively. And Justice Nariman, I think, explained it in detail. It does make sense, but then it's just, it's just not fair. What they explain is that the reason financial creditors have to be given priority is because they also contribute to the economy. And operational creditor will not have the kind of knowledge that a financial creditor would have for even him to be part of a COC. There's several reasons given this Swiss Ribbons case. While a lot of them do make sense, the issue is on fairness ultimately. What I feel is that the best way forward could be choose one operational creditor at least who has the highest amount of debt to be recovered. So you choose that one operational creditor and put him in part of the COC. That should at least take care. But going back to your question, yes, I think it's unfortunate that operational creditors are not given their due. There are two things that the Supreme Courts have delved into. One is called the haircut and one is called the waterfall. In the waterfall, basically what trickles to you, quite often nothing really. But they did come up with the haircut method wherein they say banks and financial creditors should take a cut. Thereby, at least operational creditors do get something. So the haircut method, if it is followed, I think nothing much would be lost. But in most of the cases, in reality, it's not the case. Operational creditors don't get much.
Well, ma'am, there are several more questions coming. We must ask for your availability if you're still available, because
But I
questions
think
are there.
If there are just 2-3 more, no
Yeah, yes,
problem. Please go ahead. Go ahead.
Govind, I think very pertinent
Okay.
to ask this question with regard to 138 NI Act. Could you please
Yeah.
read out that?
Yeah. So over here, ma'am, this by anonymous here. If proceeding under 138 of the Negotiable Instrument Act is pending, and the IRC is appointed by the NCLT, what effect it has on the said proceedings before the NM court?
Two are separate entities altogether. In fact, the Supreme Court's gone into this aspect also, and stated clearly that you can still proceed in the negotiable instruments case. This case will proceed separately. So you can't say that I have a stay in my, in my check bounce or the NI 138, and therefore you shouldn't proceed with this because that is yet to be determined. No, Supreme Court's held very clearly that you can proceed.
Okay, ma'am. Okay, I'll move on to the next question. Last question, ma'am. This is from Mithuli. If there is an injunction by a commercial district court against Section 14 SARFAESI notice, can the NBFC go to IBC?
Sorry, if there is a stay on the Section 14?
If there is an injunction by the commercial district court against Section 14 of the SARFAESI Act,
yes.
SARFAESI notice, can the NBFC go to IBC?
See, 14 ultimately covers only where you have your guarantor or any of them. Now you're talking about them moving the IBC. They have the authority to move the IBC not against the person. They're going against the loan. You understand? So they are at liberty to go and approach that court.
All right.
Those are two different aspects. Under Section 14, what they initiate, which they have the liberty to do so even when 13.2, 13.4 is not even started also, they can still parallelly go on Section 14. But that doesn't prevent them to go to the IBC because they're not targeting any particular person. They're looking at the loan recovery. Does that answer the question?
Yes, I am pretty sure Mithuli ma'am answered the question. If not, you can ask the follow-up one. I think that will be the last question. There are more coming in, ma'am. If there are any, we'll send you. But there is something Mr. T. Sarosh and Associates written. Thank you for your impassioned and eloquent case made out for reform. It should be memorialized and submitted to the Finance and Legal Ministry for the case of the reform, ma'am. You made a good case here. I will definitely say that. We all know that laws what on paper are, but what they are in practice is something we really need to understand, and that's where reforms are. And you made a very good case, ma'am. It explains everything from start to end and exactly where the gaps and the lacunas lie which have to be filled in.
Correct.
Yes, ma'am. Thank you. So, should I move on to the thank you note? What should I do? Should we
Right. Mr. Raghav, do you have any more questions?
We do have two questions right now. If I could
very quickly, you can just pose it. Otherwise, if we are running short of time, then we will handle it offline. So I would request, ma'am, can we just pick up one question, one last question?
Yes. Go ahead.
Mr.
Yes, ma'am. She's very particular. She needs the answer to something. She's written this quite a few times.
Yeah, that's what I was talking about. So Ms. Jayasima wants to ask if your suggestion to accept money under OTS and to allow borrower to pay remaining balance under fresh loan, banks will use this option to manage NPA accounts arbitrarily.
Oh, they're always going to find a way out. But this was more in terms of looking out for the borrower. In an OTS scheme, if you're able to wipe out a lot of your debt and keep a negligible amount as a separate loan, maybe it'll at least keep you surviving. Because I'm looking at saving your other assets, which you're going to lose everything otherwise. So this was just a suggestion, but of course, yeah, they're going to find all kinds of routes to get back at you. So that I really can't say. This was just a suggestion. I mean, this is something that I thought of.
Thank you so much, ma'am. Govind, I think maybe we can conclude now.
Okay. Thank you. And I think we've received a thank you. Jayasima ma'am is saying thank you for Mithuli ma'am. those are thank you to Dipti for clarification on the query. So thank you, ma'am. Thank you so much for the lecture. Everything crystal clear, very enjoyable and very crisp lecture. I would just like to thank everyone. I would first and foremost like to thank the audience. I would like to thank ma'am. Because of both of them, the lecture wouldn't have been possible. Such an engaging and such an interesting lecture. I would like to thank Mr. Raghav Arora from Lawyers Club India, and I would like to thank Mr. Trivikram sir from Trivikram and Associates. And I'd like to thank everyone for being here and for a great evening and a very knowledgeable and good evening. Please, everyone, stay safe. Thank you.
Thank you so much. Namaste.
Thank you, ma'am. Thank you.
Once again, thank you, ma'am, for a very eloquent and very stupendous presentation. Thank you so
Thanks,
much.
Trivikram.
Thank you, one and all.